please the court, my name is Attorney Steve Shaparka. I am here on behalf of Shelmar Realty. I did not, or I requested oral arguments, but obviously the appellant has not. I'm more than willing to answer any questions that the court may have on this case. It's a pretty much a routine slip and fall case outside a mobile home, at a mobile home park. The case was briefed by both the attorney for the appellant as well as myself. The appellant acknowledges that this was an open and obvious snow and fall type situation. He was walking down steps and stepped onto a concrete pad outside his mobile home and slipped and fell. He acknowledges that the property owner did not have superior knowledge of any defects with the property. The sole issue in this case involves the Landlord and Tenant Act, and most importantly, in particular, the section of the code which requires that a landlord keep the property in a fit and habitable condition.
Counsel, let me ask you a question.
Yes.
I just want to clarify the gutters and the awning. You indicated, I think, in the brief that they had never been on this particular mobile home, or did I misread that?
There were gutters and awnings at one point when the mobile home was not owned by the defendant. This particular mobile home was acquired through a share sale or a foreclosure action. And when he bought the property, the gutters and awnings had already been removed and sold by the former owner. So at the time of the transfer, they were not there. If that answers your question.
Did the mobile home transfer to the appellant? Was he the owner of the mobile home? Okay.
No.
So the time of the transfer to the landlord, there were no, okay.
Yes.
Was there any argument, further discussion that we'll find in the record about whether or not that patio was a common area?
In my motion for summary judgment, I argued to the court that this was not a common area. Mobile homes are somewhat different than apartment buildings because there's not a common entrance that all residents go through. When we rent a pad, grassy area with a concrete pad, little patio, and then the typical mobile home or manufactured home sits on that concrete pad. So no, that would not be a common area. The patio was exclusively to that particular homeowner. And what was critical that I pointed out in my motion for summary judgment is that the rental agreement specifically provides that the tenant is responsible for clearing snow and ice from their particular property. And the plaintiff acknowledged in his deposition, which has been part of the record, and quoted it in my summary judgment as well as in my public brief, that he acknowledged that patio, sidewalk, steps were all his responsibility for clearing. And so he does not deny the fact that it was his job to clean off that snow and ice. And we have pictures that are part of the record. They were part of his deposition, which showed what the condition was on the day that he fell, or the morning that he fell. And there's a lot of snow and ice. So obviously, it wasn't clean like he should have.
One of the arguments, obviously, he makes is that it was impossible to keep up with it due to the unnatural accumulation of snow and ice.
And I think that argument truly falls away at the wayside, because if this was a situation where the steps were perfectly pristine except for glazing over them as though water had dripped down and frozen, I suppose he might have an argument that he couldn't have known that the ice was there. But if you look at the photographs, there's piles of snow on the steps. There's piles of snow on that concrete walkway. It's pretty clear that he did not, in fact, use any effort to clear the snow and ice off that property.
So was there an issue of fact as to whether or not it was a natural or unnatural accumulation then?
Not from our standpoint, Your Honor. The issue comes...
Yeah, I got that from the brief.
Well, I think the law is pretty clear that when water drips off a gutter, or when water drips off a roof, or an awning, it's not uncommon like with commercial premises to have cloth or metal awnings, that if water's just dripping and then refreezes, that's a natural condition. So in this case, there's no question that the plaintiff's argument is that the water dripped off the roof and ran down the steps and froze, even though I don't agree with that. But even if you assume his argument's correct, natural freezing or cycles of thawing and freezing is still natural.
But the placement of where that takes place idea of gutters is to direct the water to, down through the downspout so that it doesn't accumulate in places of ingress and egress, right?
Your Honor, I think that the issue, it depends if you look at it from a legal standpoint or perhaps a moral standpoint. I mean, maybe a landlord of a big apartment complex should put gutters up to divert the water. But when it comes to mobile homes, the evidence is clear from the deposition of the owner and the maintenance man that all mobile homes come from the manufacturer without gutters. That's not something that the manufacturer builds when he makes a mobile home. One would think that the manufacturer would understand the risks of when they manufacture this product, of what the dangers are. And also, the owner testified that most homes in this complex of 100 and some units do not have gutters or awnings. That's something that is what they call an accessory. That look, if you want a gutter or awning, you can pay for it and have it put on your unit, but it's not a standard accessory.
Follow up with Judge Moore's question. Is there anything in the record how many units were actually rented out in that mobile home park?
There's mention of that in the owner's deposition, in Mr. Latif's deposition, and I'm thinking it's 120, 130, something like that.
That are rented?
That are rented. Well, some units are owned by individuals, like you buy a unit and you bring it in and you put it on our lot. Some units, like this one, are actually owned by the property owner.
Well,
but
that's the
property
question
owner,
I'm asking.
I think about 30 or 40 are actually owned by the park and just
Yes.
rented.
That's what I'm asking, because obviously you rent the lot.
Rent the lot and rent the unit.
Okay. Well, okay, we're still not on the same page. Usually, in a mobile home park, people have mobile homes, and they take them to have some place where they can park them and have access to water and sewer and so forth, and then you pay for that access, but you are the one that owns the mobile home. So I'm not talking about those people.
Okay.
I'm talking about the people that are actually in units or mobile homes that are renting them from the mobile home park owner, Shelmar here. So was there something in the deposition that says, and is that the 30 or 40 amount you're talking
Yes.
about?
Yeah, it's a much smaller number.
Sure. Now, let me ask you this, of those 30 or 40, was there any further questioning or any evidence as to whether or not they have gutters?
That specific question was not asked in the deposition.
Because the reason why I'm asking, obviously, is we're talking about a landlord-tenant situation. It doesn't matter if a property owner, right, if a property owner doesn't put gutters on their own property, that's their choice. It's a matter of whether a landlord has to provide the gutters as part of his duties as a landlord.
Correct. I would agree with you, Your Honor. And the testimony of the owner and the maintenance man is that, again, a majority of the homes do not have gutters and awnings.
But what does that matter? Who cares? Because the point is we're looking at what the duty of the landlord is, not what a separate property owner does or doesn't do with this. If a property owner wants, as Judge Moore said, take the risk of the water just running all over the place and not being directed out through gutters, that's their choice.
I agree, and I guess the point I was trying to make, Your Honor, is that when the owner answered that a majority don't, I understood he meant a majority of the homes that they rent do not have gutters and awnings. Because again, that's an optional accessory that the renter would have to ask for. And I think in terms of legal duties, which is what the point I was trying to make with Judge Moore, maybe didn't make it accurately, is that the legal duty under the mobile home statute or even the landlord-tenant statute only talks about fitness and habitability. And Ohio courts that have interpreted that statute, including the Ohio Supreme Court in an indirect fashion, in the LaCourse case, which is quoted in my brief, have made it perfectly clear that the legislature didn't say have to keep it, remove snow and ice, or, the legislature specifically included in the statute the provision that we only have to keep it fit and habitable. And Ohio courts which interpreted fit and habitable have clearly said that that means something more than just insubstantial, trivial defects. This means something that would make the premises uninhabitable, unfit for human consumption. One of the cases that I found last night that I did not quote in my brief, which I think is excellent.
Well, we can't do that
Okay, then I won't mention it, Your Honor.
Unless
But
you
again-
file a motion for additional authority, I'm
Okay.
sorry.
But the point is that it has to be unfit or uninhabitable. Insects, no heat, no water, those types of things that make a property, that would almost enable a tenant to go to the municipal court and say, I want to escrow my rent because my landlord is not making these repairs.
But
This is not that situation.
what if it's the type of thing where the water's running off because there's no gutters and it's running right into the steps and the entrance where you enter, and you really can't enter your home because it's so constantly filled with ice, or covered with ice?
Your Honor,
Wouldn't that make it uninhabitable because you can't even get in?
well, I think there's an issue first whether that's the sole method of getting into the property.
Well,
That's
let's
not
say
this,
it is.
that's not this case either. There was another back entrance that had wooden steps that he could have used if, so that's not this
Back
issue.
entrance, what now?
There's a back entrance to this mobile home park on the opposite side with wooden steps that he could have
And
entered.
that's in the record?
I'm not sure that the argument was ever made before or defended by the appellant's counsel.
Are there photos?
There are photos that I have, but again, I don't think they were brought up in his deposition. There may have been, I don't recall, I'm sorry.
That's all right.
But nevertheless, Your Honor,
We'll-
answer your
what do
question.
you mean, we'll look at the record? Go ahead, I'm sorry.
To answer your question, I suppose there could be extreme situations where just nothing could be done. But if you look at the photographs in this case, these were brand-new steps. The property owner, the landlord, bought brand-new steps with skid pattern on the footing area to keep it from being slippery. The landlord did everything he could to not create that type of a situation. But again, the tenant owed some responsibility to clear the snow and ice. And he didn't live up to that obligation, which he acknowledged in his deposition. This is not a situation where the property was uninhabitable or unfit for human consumption. In fact, what's interesting is that this man was he found his unit eventually because he was hired to remodel the unit. He was a local guy, a local handyman who was good with the trades. So he asked, and he was hired to remodel this mobile home. So he went in there and gutted the kitchen cabinets and gutted a lot of the flooring and all that. And after he fixed it all up, so it was in a position to be rented to other people, he contacted my owner and said, I'd like to rent this place because it's nice. So this particular plaintiff actually fixed it up to the point that he wanted to rent it. And one would assume that if this house was unfit for human consumption or uninhabitable, he wouldn't have wanted this unit so bad to rent it. So again, Your Honor, the trial court correctly followed the landlord-tenant statute. The trial court correctly followed the Court of Appeals decisions which interpret the term fit and habitable in the statute. And we would ask this court to also affirm the trial court's decision, also finding that the minor and insubstantial type of an issue that the plaintiff is trying to raise does not rise to the level of being unfit for human consumption or uninhabitable. So we'd ask the court to affirm the trial court's decision in this matter.
Thank you.
Thank you, Your Honor.
Thank you. Thank you for your presentation. We will send you and the other side the written opinion when it's prepared, and we've also released it on our website.
Thank you.
Have a good day.